Hi, I'm Sayuri Kagami.
And I'm Paul Trudelle.
Welcome to Hull Estates. You're listening to episode 557.
How are you today, Siri?
I'm good, you?
Very good, thanks. We thought we'd spend some time today talking about a recent decision of Justice Dunphy out of the Ontario Superior Court of Justice. It's a decision that has the estate planning bar a little panicky and rushing back to their wills vault just to make sure that their wills aren't offside. It's a decision. The decision is Re Milne Estate, and it deals with the validity of multiple wills. Maybe we can talk a bit about the state administration tax scenario in Ontario, the regime for that, and payment of taxes, and what the bar has done, what lawyers have done in order to minimize the estate administration tax payable, and how that there was a glitch in that was caught by the decision in Milne.
Yeah, so, if we go back to basics, most estate trustees will find that when you are appointed as an estate trustee of an estate, you have the will in front of you, and you'll go to a bunch of third parties with this will. And some of them will say, well, how do I know that I can trust you to be the person that I'm supposed to be dealing with?
Right.
So we have a mechanism where we go to court and we get probate, where the court certifies that, yes, this is the proper person to deal with all these assets.
Right.
But when you do that, you have to pay estate administration tax.
Right, and you need that for certain assets. Most banks won't deal with you unless they have probate. To transfer certain real property, you need to have probate. It's now called a certificate of appointment. In other scenarios, you don't necessarily need to have a certificate of appointment. If you're dealing with shares in a privately held corporation, if you're transferring, art or other personal property like that, you don't need the certificate of appointment. So if you don't need the certificate of appointment, you don't need to apply to the court for probate or the certificate, and you don't need to pay the estate administration tax. So in Ontario, the multiple wills have evolved, and there was a case some time back that said that multiple wills is an appropriate estate planning tool. So in most cases, you'd have a primary and a secondary will. The primary will deals with assets where you need probate, and that's the will you apply to the court with, and that's where you pay estate administration tax with respect to those assets. Assets that don't need probate, they're covered in a separate will, which you don't probate, and you don't need to pay estate administration tax with respect to those.
And I think generally the way it works for a lot of practitioners is you draft these wills, then you say the one that requires probate, you say, okay, this will governs all of my property except certain assets that you list, and then your other will say, all right, this will governs all of my assets that I'm listing here, being my real property, the ones that you're excluding. So my private shares in a corporation, my artwork, my personal property.
Right. So there's certainty there as to what is going to happen. In the Milne decision, what the will provided was that the primary will dealt with all property of the deceased except for listed certain assets, and other assets which my trustees may determine a grant of authority by a court of competent jurisdiction is not required. So it covered all assets except assets that the trustees determined didn't need probate. And the secondary will governed all assets, including, and it listed certain assets, and any assets that probate isn't required for. The estate trustees then in Milne Estate applied for the certificate of appointment with respect to the primary will, and they didn't get it.
Yes.
And that's the problem. That's the issue there. The application was made. It was sent up to a judge, Mr. Justice Dunphy. He asked for written submissions, and then he asked for the council to appear, and there was a hearing on the issue of whether a certificate of appointment should issue with respect to the primary will.
Yes, and Justice Dunphy essentially found that when you are creating a will, it essentially, at the testator's date of death, creates a trust. And so it has to meet the three valid requirements for a trust, which are certainty of intention, certainty of subject matter, and certainty of object. So you're meaning to give these items away, you're meaning to give them to a specific person, and you have to specify what is being given away.
Right.
And that's the certainty of subject matter, which became problematic in this case.
And that's where this will was offside, or Justice Dunphy had his issue, because on the face of the will, he felt that he wasn't able to determine what was in or not in the will. And because of that, it didn't meet the requirements of the three certainties. And therefore, the first will, the primary will, was found to be invalid, essentially. There was an argument that when granting probate, the court doesn't need to be interpreting the will, and that can come at a later stage as to what's covered by it. But in this case, Justice Dunphy said, well, no, the role of the court can be to determine whether the will is valid or not at first instance on its face. So in this case, there was also the argument that it was certain the trustees could determine what was in or not in the will, and that certainty would be avoided the problem of creating the certainties. However, Justice Dunphy felt that it wasn't clear on the face, and there was of the will, and there was a substantial, complete discretion on the part of the estate trustees, and therefore the certainty of subject matter was not met.
And I think part of the problem there was that he felt there's two issues there. It has to be determinable on the date of death. This can't be something that comes up later on where an estate trustee realizes they do or don't need probate when they're dealing with a third party. It has to be from the date of death, you know what assets fall under which will. And the other issue is that it has to be an objective determination. So any person looking at the wills, at the assets of the deceased, can determine what falls under which will.
Right.
In this case, because it's under the discretion of the estate trustees, only the estate trustees would know. So those were the two issues that he took with this will.
Right. And the implications of the decision, in this case, luckily, the second will covered all assets. There was an the primary will was valid. The second will would cover all assets, so there wasn't an intestacy with respect to any of the assets of the estate. However, in order to deal with, if any of the property required probate or a certificate of appointment in order to be dealt with, all of the assets of the estate would fall into the second will, which would need to be probated, and estate administration tax would be payable on all assets, even assets that would otherwise not necessarily attract estate administration tax.
Right. So that's potentially a pretty big increase in fees then that this
Right.
estate is now paying. And you mentioned intestacy. So here, intestacy is voided because everything goes under that will, but potentially there are other types of wills that are similarly drafted but not completely the same. And we might be actually looking at other sets of primary and secondary wills where you have assets that are now not going to fall into the will that's still found to be valid, and therefore just have to pass by way of intestacy,
Right.
Which might be very different from what the testator intended.
Right. So I think it's important for everyone to review their wills if they have primary and secondary wills to make sure that they're not running afoul of the decision of Milne, and consider redrafting or steps that may be taken in order to avoid this type of problem. Yeah. And I understand that the court case is under appeal at this point, or may be under appeal. So
that's the rumor.
It may be that this is not the final word on primary and secondary wills at this point.
Yeah. So we'll see.
Thank you for listening or for watching. Until next time, I'm Paul Trudelle.
I'm Sayuri Kagami.
And if you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog. Thank you.